we come to question number 7 now, and that would relate to inter-country adoption. And the case in hand is Jasmine Kaur. Would you like to explain to the listeners, to the viewers, the significance in this situation of inter-country adoption?
Going a little into the background, this is an area where adoptions inter-country have, by way of judgments of Lakshmikant Pandey 1, 2, and 3, developed into new adoption laws, which led to the amendment of the Juvenile Justice Act and creation of the Juvenile Justice Care and Protection of Children Act 2015 and an exclusive chapter on adoptions. Now, inter-country adoptions were a vulnerable area where children were smuggled and sold. So we put a system in place by signing the Inter-Country Hague Convention on Adoptions, creating a central authority and putting a system whereby children could go through legal ways by agencies or adoption authorities in different countries. Now, this was very good and is very good insofar orphan, abandoned, and surrendered children is concerned, because there is a system in place. So, who decides for the such category of children? The agencies, the authorities, and most importantly, CARA in India and its counterparts in other countries. But what happens to our inherent religious and ingrained right of adoption under Hindu law, which is centuries old? And the concept was you take from the lap and you put it into another lap. The parents giving give, the parents taking take. So there is no agency, there is no authority, because the well-wishers of the child are on both sides. So these are inter-country relative adoptions. Everything is good as long as you remain in India, because you do the ceremony, Datta Homan, under the HAMA, Hindu Adoption and Maintenance Act. You take the child, you may go to write a deed and get it registered, because you have to do paperwork, meaning Aadhaar card, PAN card, birth certificate, and so on and so forth. All that is not necessary, but it helps and facilitates in documentation. So that's the end of the matter. But what happens when the child has to go abroad? It's an inter-country relative adoption, not intra-country. Now, there you need a visa, you need a passport, and you need clearances. Now, in such like circumstances, when we made the Juvenile Justice Act 2015, we under Section 56, subsection 3 said nothing in this act shall apply to adoption under the Hindu law, under HAMA. But then there is also a part in Section 56 itself saying that all adoptions have to be in accordance with the regulations under this act. So, essentially speaking, you need a no objection certificate from CARA that this adoption is taking place according to domestic law, and therefore it is good. Without that NOC from CARA, the concerned High Commission or the embassy of the foreign country will not give you a visa for the child to leave. Forget visa. The passport officer will not issue a passport. The passport authority is becoming a king in his own right. He has 13 grounds to deny me a passport under the Passport Act. But in the passport manual, he has added a ground NOC from CARA. Who are you to question the adoption? Supreme Court, the High Courts have their full decisions of our High Court, striking them down. But who listens? The passport officer sometimes is an IAS or an IPS officer. That's the end of the story. The application of mind is not there. Now, in this backdrop, when there is nothing in the law to prevent movement of children, The adoption convention also says if you have a domestic law in place recognized by the competent authority, we are good. But Kara says no, we have made adoption regulations which are actually delegated legislation but has overtaken Section 56(3) and neutralized Hindu adoption, almost striking it off. Now, this is where Jasmine Kaur came in. Inter-country relative adoption. I was an amicus in this case in the COVID period. Then came the Delhi High Court's judgment. And there is one matter in the Supreme Court, but still pending, so we cannot comment on it. But these two judgments of the Delhi High Court and the Punjab and High Court say that there is nothing in the Adoption Act, this JJ Act, or the adoption regulations, which is applicable to Hindu adoptions. Because there is no need of agencies, the parents are the agencies. But Kara says, no, you have to go and first start all over again in the country where you want to take the child. Or that country will say, what have we got to do with this? You didn't start the process here. But Kara says, no, you live there, so you start the process. Now, this is the problem. Now, Kara, headed by a CEO, who or she is invariably a senior civil servant in the Ministry of Women and Child Development. And Kara is backed by an organizing management committee, which is full of bureaucrats. There is nobody lettered in law. There is no application of a judicial mind. I think the High Court or the Supreme Court judge should be heading Kara because you're doing quasi-judicial functions. And you are changing the act by regulations. So whatever the Supreme Court did by moving forward, in my view, with due respect, Kara is setting the clock back. So instead of facilitating the adoption, instead of furthering children to find homes, instead of helping movements of children, Kara is frustrating adoptions. People are left to litigate for 2 years, 3 years, 5 years. You have to go to the Supreme Court or the High Court in a writ to get an NOC. I think that is absolutely absurd. And then having an Kara gives an interpretation that the date of adoption is the date when you registered the adoption deed. And if that date of registration is after the date when you amended the regulations, you will fall under the amendments. Now, under the adoption law, the adoption dates back to the date of the ceremony, not the date of registration, because registration is optional. It's like the Hindu marriage. If I get married and I don't register my marriage, doesn't matter because the Hindu law says it's not necessary, optional. So if I register my marriage after 20 years, it doesn't mean I got married after 20 years. Now, who will explain this to Kara? Problems, courts. But then you file a petition, then you go in contempt. So you are spending 5 years on all this. See, adoptions came back as a way to have your family children with you in the fold because surrogacy is very tough now. So you can't have your genetic material. So you go back to adoption. You must realize you have a huge Indian diaspora, 34 million. So if there has to be a movement of children within the family, why should Kara obstruct? When the convention provides it, when the JJ Act provides it, when Hamma provides it, why should you act like a turkey? Sorry to use the phrase, but this is an ostrich approach. I speak because I think I want my country to move on and I want things to change. I have spent 40 years, I have learned so much. I think it's time for me to put back into the system, like yourself, sir. On reform, we have to change our law with changing times. We can't stand out in an island, particularly when we have such a dynamic prime minister, where the economy is growing, we are multiplying, businesses are doing well. We need a stable society. So, Jasmeet Kaur, and Justice Pratibha Singh's judgment, with Justice Nirmal Kaur's judgment, are a way forward to this door. Both these judgments have not been challenged because they probably think the outcome is on the writing is on the wall. But at the same time, you keep changing. And I personally feel that if the regulations change the act, they should be struck down.
Thank you very much, Anil. This was truly a matter, a session where your articulation would help the teachers in law schools, colleges, universities, and the students at the postgraduate level in a better and clearer understanding of international family law. Thank you very much.
Grateful, sir. It was a pleasure talking to you. Thank you.